So, what we have in place prior to October 21st is a civil protection order issued by the court, Judge Ewers, and it prohibits Mr. Fuchs from recklessly doing any one of a number of things, but I just wanted to direct your attention to 1, 3, and 6, okay? Mr. Fuchs and Mr. Van Kerkhove, as I mentioned, are neighbors. They live next door to one another at 436 and 438 Oxford in the city of Elyria, Ohio. On the particular date of this violation, and I think what I'm going to tell you, at first blush, if it happened between you and your neighbor, you would probably just say, well, that was an absolutely rude, disrespectful, inappropriate thing to do. But because this protection order specifically prohibits Mr. Fuchs from certain behaviors, what he did was not just disrespectful and inappropriate and annoying, it was a violation of the protection order issue. And what happened is this. This was coming up on Halloween, and Mr. Van Kerkhove ordered through the mail, I guess online, a couple of Halloween costumes for his kids. And the Halloween costumes come in a box about like that, about the size of 2 telephone books next to one another, but very light. I think the whole package weighed 1 pound with the cardboard that the 2 Halloween costumes came in. UPS misdelivered the package, and it went not to the Van Kerkhoves, but it went to Mr. Fuchs. And at about 4 o'clock in the afternoon, Mr. Fuchs is getting off work, Mr. Van Kerkhove is getting off work. And Mr. Van Kerkhove observes Mr. Fuchs over on his porch, and he's looking at some stuff on the porch itself, near his mailbox, and he sees him pick up a package. I mean, at that point in time, he had no idea that it was his package, that it was misdelivered to his neighbor. Fuchs picks it up, looks at it, and then flings it into his yard. And that's the violation of the order. The order doesn't prohibit Mr. Fuchs from having contact with the Van Kerkhoves. Obviously, the civil thing to have done would be to say, I have a package that was misdelivered.
Objection. Another misstatement of the law. The protection order doesn't say he can't have contact with the Van Kerkhoves. Have you read it?
I don't believe it says that. I'm sure you're going to hear, well, what was he supposed to have done? I don't exactly know what he was supposed to have done. He placed himself in this position. He's subject to that protection order. And I suggest to you folks that frisbeeing a package out onto his next door neighbor's front lawn is inappropriate, and it's a violation of the protection order. I guess you could have called UPS and said the package was misdelivered, or you could call the police department. But what he did was specifically intended, and he recklessly violated the terms of the protection order. It's just further harassment, further annoyance, and just one more additional reason or way to get under his skin, and it happens barely a month after the judge signed the order, and the ink on the temporary protection order was barely dry. So the gentleman brought it to the attention of law enforcement, and here is Mr. Fuchs. The first witness that I mentioned you'll hear from is Mr. Van Kerkhove. Thank you.
Certainly the evidence will show that when Mr. Fuchs got home from work, he went to his porch, and there's a package, a 1 pound package, addressed to Eric Van Kerkhove. Now, it's addressed to Eric Van Kerkhove. It's not my client's package. Now, my client is under a protection order. Now, ladies and gentlemen of the jury, or people in the back, or perhaps the judge, or me, would pick up that package and carry it over to my neighbor's house, and knock on the door and say, hey, you brought your package over to my house. In fact, that may have even happened to you. It's happened to me before. But Mr. Fuchs can't do that. Now, I know that in the opening statement, Mr. Robach told you that he can have contact. Now, I don't know where that came from, because I'm looking at his own thing here. Number 7 of the protection order, responded. That's shall not initiate or have any contact with the protected persons. Shall not initiate or have contact with the protected persons. So how does Mr. Fox unless he pick up the package and walk over and knock on the door? You can't call him, right? He's in a catch-22. Now what do? I can't leave it here. Part of the protection order says he can't hide. You'll see it. He can't hide the package. Well, the package is hidden from the Van Kerkhoves because when you see the pictures, there's a railing around Mr. Fox's porch, and the package is hidden. So they're like at a catch-22. But I'm damned if I do, I'm damned if I don't. I think the evidence will show that that's a situation he was in. So I think the evidence will also show that he acted in the most reasonable possible manner for a person under protection order with a package misdelivered. He picked up the package, he walked to the edge of his property, did not step onto the Van Kerkhove's property, did not contact him, tossed the package onto his lawn so that the Van Kerkhoves could see it and recover it, which they did. Open the package and the evidence will show there was no damage to the Halloween costumes. That's what this case is about.
At that time, I went outside a little bit after that to check on my mail, to get the mail. As I went out to the front porch, Mr. Fox was coming home from work. He walked up to his front porch. I observed him when I looked down. He picked up a package that looked like a UPS package. He looked at it, looked at me, then smiled, then tossed the package into my yard over the front yard tree, and then walked in the house. At that time, I walked over to look at the package and saw there was the package that I was expecting with my name on it. Saw that the one corner was damaged and torn and crushed. At that time, I went and photographed where the package was to all the numerous complaints I've had. I was told to document everything and report everything.
And how did if you could demonstrate how it was that this package exited his hand and ended up on your yard? How did it happen?
He kind of tossed it like a frisbee in the air.
Did you find that rude?
Yes.
Disrespectful?
Yes.
Did you consider that to be a continuing form in light of your
leading? Fortunately, you were able to open up the box and check the contents. Am I right? Was there any damage whatsoever to the contents?
No.
So your kids got their Halloween costumes? Nothing further. Toss the package onto Van Kerkhove's property. No damage to the property. Didn't step foot on his lawn. Didn't hide anything from him. And basically did everything he could do that's humanly possible to not interfere with that package and to have it delivered and to see that Van Kerkhove would get it without initiating any contact. I think it's totally proper. I think the protection order is too all-encompassing. I mean, it actually stops him from calling UPS. If UPS came to pick up the package and delivered to Van Kerkhove, I believe that could be found as a violation. My client would have encouraged a third party to do that which he wasn't allowed to do, and that is step on Van Kerkhove's property and deliver the package. That's what it said. That's number 8, blown up right there. So I think he took the only reasonable step he could do and tossed the package onto Van Kerkhove's lawn without stepping on it, without initiating contact. Now, I don't believe that is tantamount. We believe everything that has been set forth, that is recklessly disregarding the protection order. And I'm asking the court to grant my judgment before it. Thank you.
Yeah, can I exhibit one?
his options were limited, but certainly taking a package and whipping it into his neighbor's front yard was rude, disrespectful, and it violated, as I argued, Judge, the provisions checked below apply to the respondent. And recklessly bothering, harassing, or annoying, or interrupting the delivery of documents or any other items, or removing or disposing of property apply. Thank you.
Well, I agree that the defendant was in a quandary because he's got a package that it appears from the evidence presented by the state, in no way was it his doing that it ended up on his front porch. And we have the testimony of Officer Van Kerkhove that he saw the defendant arrive home from work. So the defendant is in a quandary. Prudent thing to do would have been to call UPS and say, redeliver this, because I don't believe that calling UPS would have violated the no contact order. But that's not the bottom line here. The bottom line is, did his actions at the point that he put the package in the form that was witnessed by Officer Van Kerkhove, throwing motion into Van Kerkhove's yard, did that violate this order? I do not believe that the state has met its burden of proof this time, even looking at it according to the Bridgman standard in the light most favorable to the state, of proving that the defendant was recklessly violating the order. The definition of recklessness that I had intended to present to the jury this morning was a person acts recklessly when, with heedless indifference to the consequences, he perversely disregards a known risk that his conduct is likely to cause a certain result. And when you read that definition in conjunction with the other orders the respondent, the defendant, was to follow here, which is don't interfere with delivery, don't threaten, harm, abuse. I believe in reading this all together that the state has not met its burden of proof, and I will grant the defendant's motion for acquittal at this time. At this time, with
Thank you.
the jury.
Good job, Mike.